Good afternoon, everybody. I know everybody had lunch and everyone's looking for a nap. However, you got to stay focused, so we're going to drop the temperature to about 50. Is that okay? But I guess everyone didn't listen last time. I know it's like at church. You're allowed to get a little closer. It's okay. Okay, so we'd like for you to get up front if you can. But again, we're going to kick off the public records portion of this. We have Ms. Barbara Peterson in town from the First Amendment of the state of Florida, and Barbara did an incredible job on the sunshine, and I see a lot of people from the public that are here now, so I want to thank them, and I want to thank all the people that serve on boards and all our elected officials that are here and that are able to stay for this part of this session. And I'd also like to introduce many of you that our employees do not know Ms. Colleen Castile. Colleen would like to say a few words. Colleen Castile.
Thank you, Mayor. Thank you, Mayor Harewood. I appreciate the opportunity to serve. I have been here for a month now and have been meeting new people every day. And for those of you who I have not met yet, it'll be just a matter of time before I make my way around. It is an honor to serve the city of Pensacola. I have been in government for 20 years in my previous career in state government, and this is a great opportunity for me to get to serve a fabulous community. I have been a visitor to Pensacola, but for the last 30 days I've been here as a resident, and it's a fabulous city, and you're lucky to live here, and I'm happy to be here to serve you. So thank you, and I will meet you all soon.
Thank you, Colleen. And here is Miss Barbara Peterson. I know everyone's sitting in the audience, though, and said, since I've been the mayor, oh my gosh, another public records request. So Barbara is going to educate us, hopefully let us know the do's and don'ts and put us at ease and know that we're serving the public, as we all know. So, Ms. Peterson.
Thank you very much. Thank you. Thank you very much, everyone. Thank you, Mayor Haywood. Your staff has been so wonderful and so responsive and so helpful. I really appreciate the opportunity. I love coming to Pensacola, for one thing. But I really appreciate the opportunity, and glad to see so many people turned out today for this. And we're going to be doing another one this evening, so if you have friends who had to go to work, tell them to come tonight, 5:30. I didn't tell Tamara this, but I did one of these in Fernandina Beach a few years ago, and we had the two during the day for employees, and we had one that night. And the two people who showed up, and I sat down at a table in the coffee shop and talked for a couple of hours about open government. So encourage your friends to come. I have two questions from this morning, so I'm going to take just 1 minute to answer those, and then we'll start talking about the public records law. For those of you who weren't here this morning, we were talking about the Sunshine Law, the Open Meetings Law, and the questions I got at the end on the cards. The first question is, in a public body, commission, we'll say, is having a meeting discussing a certain issue. And at that meeting, they tell everyone in attendance that they will be holding another meeting on the topic the following day. So at a publicly noticed meeting, they announce that they will have another meeting on the topic the following day. And the question is this reasonable notice as required under the Sunshine? And the answer is no. To announce at a public meeting that you will be holding another public meeting the following day is not reasonable notice. If you remember when we were talking about what the courts have said reasonable means, they said sufficient so as to inform the public who may be interested in attending. It could be that I couldn't get to today's meeting, but I could get to tomorrow's meeting. There's no way for me to know about tomorrow's meeting without having been at today's meeting. So I would say there's some other type of notice is going to be required to satisfy that reasonable notice requirement. Now, the second question had to do with minutes. A public body, say a commission, is holding a meeting and they tape record the meeting, but they never transcribe those minutes. Is that a violation of Sunshine? And the answer is yes. There must be minutes. The Sunshine Law requires that minutes be taken. It does not require that a tape recording be made. Under the Sunshine Law, there are other meetings provisions that might require recording. So if we tape record the meeting, most agencies will record the meeting and then they take that recording and transcribe it, and then they have their official minutes. Those minutes must be recorded in the official records books. So a recording of a meeting is not the minutes. You have to, if you record, you then have to transcribe those recordings for your official minutes. So just to have the tape recording and never transcribing them, that would be a violation of Sunshine. Okay? Okay, so those are my two questions about Sunshine Law. Now we're going to talk about public records, which I keep saying is so much easier than Sunshine Law. Again, when we talk about public records in Florida, we start with the Constitution. A lot of people don't realize that Florida is one of 5 or 6 states that has a constitutional right of access to the records and meetings of its government. And what's unique about Florida's law, Article 1, Section 24A, which is our constitutional right of access to the records of government, applies to all 3 branches of government, to state agencies, to local governments. Those are included within the executive branch. It applies to the executive branch, to the legislature, and to the courts. We are one of, I don't know, maybe 2 states that have a constitutional right of access to the records of all 3 branches. Actually, we might be the only one, because Colorado has a constitutional right of access to legislative records, but not to the records of its court. The Federal Freedom of Information Act allows you access to the records of the executive branch of the federal government. You do not have a right of access under FOIA to congressional records or judicial records at the federal level. So Florida really does set the standard for openness. And I get calls from people all over the country, people in other countries, and using Florida as a model. I get upset because they come to, I had a contingent from Japan a couple of years ago, all came to my tiny office in Tallahassee. I said, I'm perfectly willing to go to Japan. Please, let me go to Japan. Mexico has recently adopted public access policies and laws very similar, based on Florida. Peru has very strong open government laws based on Florida laws. I've talked to people from Albania, a lot of people from South Africa. It's very interesting how we do set the standard for openness. That's because we have really good laws. They don't always work as well as they should, but we have really good laws. And I'm very proud of the fact that we have such good, strong, open government laws in the state of Florida. So in the Constitution, every person has the right to inspect or copy any public record made or received in connection with official business of any public body, officer, or employee of the states or persons acting on their behalf. This specifically includes the legislative, the executive, and the judicial branches of government, counties, municipalities, and districts, and each constitutional officer, board, and commission. Anything related to public business made or received by any public body, officer, or employee of the state. So when we were talking about Sunshine Law this morning, that applies to the members of the collegial body as a rule. The Public Records Law applies to everybody. So whereas staff might not be subject to the Sunshine Law, staff is specifically subject to the Public Records Law under the Constitution. So state agencies and local governments fall under Chapter 119. That's our public records law. It was first codified in 1909. It was one of the first in the country. Before it was enacted, the courts recognized a common law right of access. So we've had a very long, very strong tradition of open government in Florida. The legislature is not subject to Chapter 119. They have a constitutional duty to provide access to public records. And then they carved out some exceptions for themselves that you can find in Chapter 11. So if you're making a public records request for legislative records, you cite the Constitution and Chapter 11. The courts are not subject to Chapter 119 either. We have a separation of powers issue there. So it's constitutional right of access, Article 1, Section 24A, and Rule 2.420, the Florida Rules of Judicial Administration. And access to court records and access to legislative records is very different from access to state agency and local government records under Chapter 119. And we're talking today about Chapter 119 unless somebody has a question. And I should mention the question policy. If you have a question you want answered, there are microphones on either side. You're welcome to come up as I'm talking and ask your question. If you have a specific question, did we give note cards out again? So everybody's got a note card, you can write it down. We'll answer those questions. If I don't have time, if you put your email address on it, I will answer it as soon as I get back to my desk. So if you weren't here this morning, you don't know that I have questions for you to answer. Here's the first one. Mr. Smith requests a copy of a personnel file over the telephone and says he'll be in later that week to pick up the records he's requested. When he arrives at the personnel office, he's told he has to make the request to the city clerk. Does Mr. Smith have to make his request for a personnel record at the city clerk's office? No. Section 119.07, parens 1, parens A, says every person who has custody of a public record must allow that record to be inspected and copied by any person at any reasonable time, under reasonable conditions, and under supervision of the custodian of the public records. So the legislature, in enacting this, makes a distinction between those people who have custody of public records and the custodian of the public record. The phrase custodian of the public record is defined as the person responsible for maintaining the office having the public records. So it's the custodian's job to make sure that every person who has custody of a public record understands the requirements of the public records law. I am not required, if I go to the personnel office, and the personnel office has personnel records, and I make a public records request for the personnel file of John Smith, the personnel office cannot make me go to the city clerk to make my public records request. Every person who has custody. Now, the custodian is authorized to designate others to permit inspection and copying, but they have to disclose the, who that designee is. So the phrase custodian of public records is defined in statutes, and the courts have concluded that that statutory reference does not alter the duty of disclosure imposed by 119.07 parens 1 on every person who has custody. And this is really important because a lot of agencies around the state have adopted, in fact, Governor Bush did this. He had a policy that every member of the media had to go to his public information officer to make a public records request, and every member of the public had to go to his general counsel to make a public records request. That's not allowed under the public records law. I should be able to go to any person who has custody of that public record. Now, I could go into the personnel office. Personnel director's on vacation. There's a young person who's been there for 2 weeks manning the office. I go in and make a public records request. She doesn't have a clue what I'm talking about. She doesn't know what's exempt. She doesn't know what she has to provide access to. Can she call the city clerk and say, I've got a public records request and I don't know what to do? Absolutely. And she should be trained to do that. To ask questions when she's not sure. But as a matter of rule, you can't create conduits through which all public records requests must flow. You can adopt a policy that says, okay, personnel staff, if you get a public records request, please let the city clerk know, because she's tracking these and she wants to make sure that the law is complied with. To have an internal policy requiring employees to notify the city clerk is perfectly acceptable. But to make the public make all of its public records requests, we had a case, it's been a number of years ago now, where it was a small rural county, had a policy that all public records requests had to go through the county clerk, and she was on family medical leave for 6 months. So what do? We wait until she gets back. No, can't do that. Agency. Who has to provide access to public records? Is defined as every state, county, district, authority, division, board, bureau, commission, and any other public or private agency, person, partnership, corporation, or business entity acting on behalf of. And we talked about that some this morning, that phrase, acting on behalf of. And a private entity acting on behalf of a government agency will be more likely subject to the public records law than the open meetings law. After the presentation this morning, I was talking about a case that came up a few years ago where the National Collegiate Athletic Association, the NCAA, purely private corporation, was found to have violated the public records law because it would not provide a copy of a public record it had in its custody pursuant to public records requests. And the first DCA found the NCAA, a purely private corporation, had violated the public records law. And there's a new provision, and it's causing a lot of consternation. It's now effective. It became effective July 1st, Section 119.0701, which stipulates that all agency contracts for services, not goods, services, must contain a provision requiring the contractor to comply with the public records law and to provide the public with access to public records under the same terms and conditions and the same cost as the public agency they've contracted with. That's not really, that first part, because they're acting on behalf of, that's not really new. But what is new is, one, that they're subject to the same terms and conditions as the agency. And what brought this about was last summer, a citizen called me, and he had made a public records request of a state agency. And that state agency had contracted out its legal duty to maintain public records. So it turned all of its public records over to a private company, which acted as the warehousing for all of this agency's public records. And this citizen wanted a copy of a document that is 1 page long. Every vendor has to file something called a certificate of compliance, basically saying we're in compliance with the terms of this contract. So this citizen wanted a copy of that 1 page document. It should be relatively easy to find since they have to file it. He called me up when he was asked to pay $3,700 for this 1 page document. The private vendor in charge of maintaining public records for the state agency said, well, it's going to take us 10 to 12 hours to find that one-page document, and we charge $175 an hour. No. So this is meant to fix that problem. That document, and he did ultimately get it for 15 cents, which is what he should have paid, 15 cents versus $3,700. He ultimately got it for 15 cents. This now says that that contractor has to comply with the fee provisions in Chapter 119. And then the third thing that's very important about this, the agency, the contracting agency, is responsible for making sure that its contractors comply. Before, when we had a problem like with the NCAA, we had to go to court and file a lawsuit. And the NCAA has what we call deep pockets. I call it Bigfooting. You know, I've got one little attorney and they've got a team of attorneys. My little attorney doesn't have a lot of money. Theirs big, lots of money. So Bigfooting. Every time we turned around, we're getting hit with another motion, another this, another that. Now it's the agency that's going to be responsible for making sure that its vendors are complying with the law. And that's very important for the citizens in this state. We can talk, I can talk anyway, forever about the lack of enforcement mechanisms in the public records law, and this is one of the weak points in the law and what really drives up the cost of compliance, because we don't have an agency responsible for enforcing the public records law in Florida. So who can request public records? The word person. Every person has a right. Person is defined to include individuals, firms, associations, joint ventures, partnerships, estates, trusts, corporations, and all other groups or combinations. So who has a right of access to public records? Everybody has a right of access. You do not have to be a citizen, you do not have to be a resident. Prior to 1976, there was a citizenship requirement in the law. You had to be a citizen of the state of Florida. Odd, because you didn't have to provide identity, so how do you prove you're a citizen unless you provide identity? So the legislature took it out. So there's no citizenship limitation. Every person has a right of access to public records. I worked with a woman years ago now who worked for a state agency, and she made a public records request of her employing agency. And the agency denied that request, claiming she was not a person under the law. What? I mean, then that begs the question, well, if she's not a person, what is she? And how did she get employed if she's not a person? But they would not give her, and she sued them and she won. So the courts have said the law provides any member of the public access to public records, whether he or she be the most outstanding civic citizen or the most heinous criminal. The fact that this person making these public records requests is the biggest pain in the butt this side of Montana does not diminish the right of access to public records. I worked with a guy for a number of years. I think he must be deceased now because I don't hear from him anymore. He was convinced that his supervisor of elections had records that she was not providing him. So every Friday, he would make the same, and this went on for years, the same public records request every Friday. He would mail her the request and he would mail her a check. And when she received that on Tuesday, she would mail to him exactly the same document she had mailed him the week before and the week before that and the week before that. Same public records every Friday. He had a right of access to those records. And I couldn't convince him that she only copied those records once and then just kept recopying them, that she didn't do an independent search every time he made a public records request. But as long as he paid for his records, the cost of duplication, he had a right of access to those records. even though he was a total pain in the butt. So the motivation of the person seeking the records does not impact that person's right of access. This actually, I'm citing a case here from 2002, but it actually goes all the way back. I think the first case that said motivation is irrelevant was in 1898, where a commercial, he was a real estate developer, actually, was going into the clerk's office, the county clerk's office, and making extracts from the public records, writing down who was recording deeds and things like that, when we still recorded them in the county courthouse. And the clerk said, you can't have those because you're using that information for a commercial purpose. And the Florida Supreme Court in 1898 said it doesn't matter why he wants them. Doesn't matter what he's doing with them. That's his business. They're public records and he has a right of access to those records. There are very few cases in the law where it says you can only use this for a certain purpose, and we'll talk about a couple of those exceptions. So that his motive in seeking public records is irrelevant. And the fact that a person seeking access to public records is going to use them in a commercial enterprise does not alter the right of access under the public records law. In the Micro Decisions case, the guy was going in and making public records requests for the property records of all of the property appraisers in the state of Florida. He would then take those public records and he'd digitize them and make this nifty little like app thing that he'd sell to real estate brokers. And doesn't matter what he's going to do with it. He has the same right of access as I do. I'm just curious, want to see how many properties are being sold in Leon County. We have the same right of access. So a staff member recorded yesterday's staff meeting. We know from this morning staff meetings are not generally subject to the Sunshine Law. Reporter Rick comes in and wants a copy of that tape recording. Can he have it? City was under no obligation to record that meeting. It's not a meeting subject to the Sunshine, but they recorded it. Can he have a copy? Absolutely. Public record means all documents, papers, letters, maps, books, tapes, photographs, films, sound recording, data processing software, or other material, regardless of physical form, characteristics, or means of transmission, made or received pursuant to law or ordinance, or in connection with the transaction of official business by any agency. Everything is a public record. And in case we didn't get it, the court said, any material prepared in connection with official business intended to perpetuate, communicate, or formalize knowledge. So anything intended to perpetuate, communicate, or formalize knowledge regardless of physical form, characteristics, or means of transmission. If it relates to public business, it is a public record. Voicemail can be a public record. You've been sitting in this auditorium all day, you go back to your office, you've got 35 voicemails, all relating to public business. So it's intended to perpetuate, communicate, or formalize knowledge. It's a public record. Now, it doesn't have any retention value once it's received by the person for whom it was intended. So you can go back to your office, you listen, delete, listen, delete, listen, delete. But if you save one, and I come in tomorrow and make a public records request for all your voicemail, you're going to have to give it to me. Or those little pink slips, so-and-so called at such and such a time. I have boxes of them. I save them. Because I'll remember somebody called me and asked me this question. So I'll go back and look. You can throw those away, they're public record, but you can throw them away as soon as you get them because the retention value drops to 0. But if you save them, I think Clarence Thomas and I are probably the only people in the country who save them. If you save them, you have to provide access to them. So anything intended to perpetuate, communicate, or formalize knowledge regardless of physical form, characteristics, or means of transmission. That phrase, means of transmission, is really important. The law was changed in 1995 to add, it used to say regardless of physical form or characteristics. And in 1995, the legislature was trying to make it clear that email correspondence related to public business was a public record. And so they added that phrase, means of transmission. And there are these organizations around the country who make it their business to go around and rank states and their open government laws and their transparency. And Florida always gets dinged because we don't say email in that laundry list. We say means of transmission. Well, I was working for the legislature at the time, and I actually wrote that language, so I know what it was intended to do. If we had said email in 1995, if we left it regardless of physical form or characteristics, we added email, would we have access to tweets today? Probably not. To pins? Anybody know what pinning is? It's BlackBerry to BlackBerry communication. Doesn't even go through a server. We wouldn't have access to text messages. But by being vague, regardless of physical form, characteristics, or means of transmission, we don't have to change the law every 6 months to keep up, and even every 6 months is not sufficient. I mean, who heard of tweeting 3 years ago? Maybe some of you. We wouldn't have to change the law constantly to keep up with the new technologies, which move at the speed of light. I was shocked when I went in to get my husband an iPhone. You know, they change them like every 2 months, 6 months. There's a new phone with new capabilities that can do new things that we couldn't do before. Facebook. The Attorney General has said placement of material on an agency's Facebook page is presumably in connection with the transaction of official business and thus subject to the Public Records Law. So your Facebook posts, if it's related to public business, your Commissioner Smith, you have Commissioner Smith's official public Facebook page. Anything posted to that Facebook page is a public record. Now, that's not to say that Commissioner Smith's personal page is a public record. But anything, if you have a city Facebook page, and a lot of cities and local governments are doing this now to better communicate. But here's the rub. Everything has to be retained and maintained. So all of your posts have to be retained and maintained according to law. Facebook does not let you set your archival settings. Facebook determines your archival settings. So a lot of agencies are now every Friday afternoon or every Monday morning screen capturing and keeping paper copies because they don't know how long Facebook will keep them up there. The other problem you have is anybody who posts to your Facebook page, if it's an official Facebook page, all of those posts are public record. You can't hide them. You can't unfriend somebody. And right after Facebook became really popular, a college president called me up and he said, I don't know what I'm going to do. It's a great idea. He put up this Facebook page as a way of communicating with the students, and he was having so much fun. And then the allegations started. Well, did you know that Professor so-and-so gave Mary an A for certain favors that I won't mention? On and on and on. He said, I can't take that down. Nope, you can't. It's a public record. You can't hide it, and you can't take it down. So a lot of cities and counties and local governments now don't allow posts. You post, but you don't allow responses, because you're responsible then for the publication of that. So there's some liability there, and then there's also public records issues. The courts nor the AGO have directly addressed the issue of tweets as a public record, but those records, if intended to perpetuate, communicate, or formalize knowledge related to public business, will be a public record. And this case is in the courts right now. Orange County is being sued for public records violations, both in civil court and they're being investigated by the FDLE for a possible intentional violation of the public records law for deleting tweets and text messages. Our governor, Scott, had the first Twitter town hall in America. He got 40 tweets. When we made a public records request, we got 39 of those 40 because the 40th called him a nasty name. And there is the nasty name exception to the public records law. I'm joking, there's not. Okay, next question for you. Anybody have a question of what is a public record? Text messaging seems to be the big issue right now. It can be, as I hope we learned this morning, a violation of the Sunshine Law if we've got city commissioners texting each other about public business. Those text messages are a public record. They relate to public business. And it's not just that you have to provide access to those text messages, you also have to retain them and maintain them according to retention schedules. And that's where it becomes difficult. I've been working with a citizen in McCulloch County who made a public records request for, I think it was 3 months worth of a county commissioner's text messages. There were 7,927 texts over that 3-month period. He didn't keep any of them. I mean, that is the default on your phone, so you do have to change it to not keep them. He didn't keep any of them, and he's trying to make the citizen pay Sprint $30,000, which is what Sprint wants to retrieve those text messages. This is not the citizen's obligation to pay. He has to pay for those costs allowed under Chapter 119. He does not have to pay Sprint $30,000 to retrieve something that shouldn't have been deleted in the first place. So that seems to be the big issue. And a lot of local governments particularly are adopting policies about the use of personal communication devices to conduct public business. We get a lot of questions about the use of personally owned computers and the use of personal email addresses to conduct public business. That's perfectly acceptable so long as you're not a commissioner and violating Sunshine Law. But if you're home, your daughter's sick and you're home and you're working from home, answering emails, responding to emails, those are public records if they relate to public business. And even if you're using your personal account and your personal computer, they are still subject to public disclosure. And I always recommend to people an easy solution to that. I don't agree with these policies that say you can't use your personal computer or you can't use your personal communication device. You just have to think about it. And my suggestion and my practice when I'm subject to the public records law is to simply CC somebody. If you're using your AOL account, CC yourself at your government account, and then that email will go through the government server. You can even do that with a text message. You can CC yourself to your email address, and it'll show up in your email box. So there are ways to address that. And then there's software, which we were talking about. There's software companies that can help you with that too. But if it is a public record, it doesn't matter if you send it from your personal computer on your personal email account. It's still a public record and still subject to disclosure. And I said it this morning, I'm going to say it again. Be very careful what you put in a public record email. Once you send that, you have no control over it. And I'm shocked when school board right now, $7,000 because they need to review emails sent or received by the school superintendent because it might contain exempt student data. Why is he putting exempt student data or exempt anything in a public record that he cannot control the downstream use of? For all he knows, whoever's getting those is selling them. So you have to be very careful about what you put. Think before you send. I actually have that on everybody's computer in my office. Think before you send, because I'm the person who never thinks before I send. And I can get really outraged sometimes and forget to back up and delete stuff. So you want to think about it before you send it. And be very cautious. I was talking to a group of city employees a couple of years ago, and the city clerk came up to me and she said, "Would you please tell my employees not to put salacious gossip in public record emails?" Somebody emailed somebody else in the city, and it was, here's the sick leave policy, and then, explained the sick leave policy, and then went on for another 4 paragraphs. Can you believe what Mary's daughter did, and blah, 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 and all of this. And a reporter made a public records request for all email correspondence, and there is no exemption for that personal salacious gossip contained in a public record. So it can be embarrassing, to say the least, and you just want to be careful what you do and before you send. Okay, so your next question. Reporter Rick calls the city's personnel office and wants to know how many city employees make over $35,000 a year. The personnel director declines to answer Rick's question. Rick then says, "Look, I'm on deadline and I want a list of all your employees making over $35,000 a year within the hour." Does the personnel director have to comply with Rick's request? Eventually. His demand. This is actually kind of a trick question.
Is Rick on the deathbed?
Well, depends on. Well, you don't have to drop everything just to comply. I mean, are there any reporters in the audience? I live with a journalist. He's always on deadline. He waits to the very last minute to do anything. So I'm not too sympathetic when a reporter calls me at 4:30 and says, "I'm on deadline. Why didn't you call me at 9:30 if you needed it so badly?" So I'm not too sympathetic there. But there are two real questions here. First is the request for information. I want to know how many employees are making $35,000 a year or more. The public records law requires you to provide access to public records. It does not require you to provide information from those records. Now, I say this, if you know that you've got 12 employees who make over $35,000 a year, tell Rick. It will save you the ordeal of complying with a public records request. And a lot of people will phrase a public records request in the guise of a request for information. I want to know, or I need to know. Those are public records requests, even though they sound kind of like, there's no formal format in which we have to make a public records request. So the response there, well, I can make you a copy of the record that will give you that information. But I always include this because I get a lot of calls from government employees who work with personnel files. I just got a call and the guy wanted Mary Sue's home address and telephone number. Mary Sue is a city employee. Her home address is subject to public disclosure. Do I have to give it out over the phone? No. Tell the person if they want to make a public records request for her personnel file, you'll be glad to comply with the public records law. But you're not required to give information out over the phone, which is always why I include this. So the public records law provides a right of access to inspect and copy an agency's existing public records. It does not require that you create new records in order to comply with a public records request. So you've got a database of all of the city employees with their annual salary. You can give Rick that database and say, you figure it out. Or if you segregate it, you can give him that portion of the database. You can do a search if you don't want to give them all of the database. You have to comply with a request for records. You do not have to comply with a request for information. If you have a database, all of the data and all of the records in that database are public records. So in this case, you just dump it all into one database. You don't segregate it out by the amount. Give them the database. Or if you're not comfortable doing that, go in and extract it for him. But you don't have to comply with a request for information, nor do you have to drop everything in order to comply with a public records request. He wants it within the hour. You've got a county commission meeting or a city commission meeting tonight. There's no way. But it's Thursday afternoon, you're playing solitaire while you're talking to your niece on the phone, and you got it right there. Shoot him an email. Here it is. So it's a reasonable right of access, and there is a difference between providing access to information and access to public records. But don't get too hung up on that, because a lot of people don't know how to correctly word a request for public records. And it's, as I said, I include that because sometimes you're asked to provide information that you're uncomfortable providing over the phone. Any questions? Okay. Mr. Smith is very interested in the history of the city's parks, and he makes a public records request for all records related to park projects approved between 1960 and 1965. The records have been destroyed. He's very angry, and he threatens to sue the city. Will he prevail? Maybe is the answer. It depends. Section 119.021, parens 2A, requires the Division of Library and Information Services to adopt rules establishing retention schedules and a disposal process for public records. The law says that records can be destroyed or otherwise disposed of only in accordance with the retention schedules established by the division. So every record, every public record is assigned archival value. Junk mail is technically a public record. It's made or received in connection with official business. Department of Agriculture gets 30 copies of Turkey World every month. Do they have to keep every copy? No. The archival value is dependent upon the content of the record and not its format. So if you send a report, a bi-monthly report via email, that has the same retention value as the paper report that you used to file. When you're talking about email, some of that will be the interoffice memorandum that might have a 3-month retention. Some of it might have 5 years retention. So it's all dependent on the content and not the format. Write these numbers down if you deal with this issue. These are the most helpful state agency employees in Florida. They will answer any question you have about retention and archives. When I used to when I did my Sunshine seminars, when the state had a little bit more money, we always included a session on archives and records management. But the division doesn't have money anymore, so they don't send anybody with me. When people call me and say, I made a public records request and the agency says it doesn't have the record, my response is ask them for a copy of their retention schedule. If you destroy a record prior to its scheduled destruction date, you have violated the law. If you have questions, your records, it's usually your clerk, your city clerk. You have a records custodian who knows the retention schedules. If you have any question, you ask that person or you call the bureau. Because you do not want to destroy a record prior to its scheduled destruction date, or you will have violated the law. There was county commissioner, I believe, who didn't like the local reporter, and the local reporter was making all of these public records requests and had requested a copy of the county commissioner's cellular telephone records showing who he had been calling. It was a county-owned phone, who had been calling. And the commissioner called me and said, I've got this public records request. I said, it's a public record, you have to give it to them. So he said, okay. So the reporter calls me the next day. The commissioner set up an appointment with the reporter. The reporter goes into the commissioner's office, because I said, you have to let him see it. And the commissioner holds up the cellular telephone bill and says, see? And then rips it up into like 9,500 pieces. He got in a little bit of trouble. You can't destroy them prior to their scheduled destruction date. So, after being sent back to the personnel office, Mr. Smith is told that he has to fill out a form in order to obtain the records requested, and that the city policy says he has to wait 72 hours to get the requested records. He has to fill out a form, and then he has to wait 72 hours. Can his request be denied if Mr. Smith refuses to fill out the form? As a rule, no. Does he have to wait 72 hours to get the records? No. Sometimes he might have to wait more than 72 hours, depending on the size of his request. Federal law says that a federal agency must respond to a public records request within 10 days. And what that means is on the 11th hour of the 10th day, you get a letter from the federal agency saying we're working on it. And then 8, 9, 10, 12 years later, you get your public records. Florida law does not have a time restriction, and agencies are not allowed to impose time restrictions. Agencies cannot impose rules or conditions on the right of access that operate to restrict or circumvent that right. So, absent specific statutory authority, agencies cannot require that requests for records be made in writing, or that a requester provide identity or the reason for the request. Who they are and why they want the record is irrelevant, as a rule. And you cannot make people put requests for records in writing. Court records, if you go to the clerk of court and you want court records, you're required to put your request in writing under Rule 2.420. You don't have to tell them why you want it, and you don't have to tell them who you are. But under our Public Records Law, Chapter 119, you can't make people say who they are, why they want it, and you can't make them fill out a form. Now, you might have a form that you use internally to track public records requests. That's fine. You can make your employees fill out that form. So-and-so, dressed in a turquoise sweater came in at such and such a time and made a public records request for these documents. That's okay. You can keep your internal log. You can't make me sign anything, provide identity, or fill out a form. I was working with a city down in southeast Florida, and they'd gotten in some trouble because they had a form and they wouldn't give you public records unless you filled out this form. So I was working with them on their public records policy, and they revised it. And they sent me the policy, and attached to the policy was their new form. You can ask them to fill it out, but you have to make it clear that it's voluntary. And so what they had put at the top, completion of this form is not required by law. However, if you want your public records, you better fill it out. Something to that effect. There are some exceptions to this general rule. Anybody here work for the school board? School board personnel files. If a school board gets a public records request for a school board personnel file, the school board is required to keep a record of who is requesting the personnel files of school board employees. It applies to school boards only. And it's identification only. So if I want the principal's personnel file, I'm going to have to show them identification, but I don't have to tell them why I want it, and I don't have to put my request in writing. And it applies to school boards only. It does not apply to cities, counties, sheriffs, state agencies, nobody else. Anybody here work with car crash reports? Under a law passed a few years ago, car crash reports, the identity of victims involved in a car crash, is exempt for 60 days following the crash. Day 61, everything becomes public record. But it's exempt for 60 days. During that 60-day window, when the identity of the victims is protected, the victims can get it, the lawyers can get it, the insurance companies can get it, the attorneys representing the victims can get it, and the media can get it. I can't go down and find out who was involved in that terrible car crash at my corner, but I can read about it on the front page of the newspaper the next day. In that 60-day window, those people who are authorized to receive it have to put their request in writing, and they have to verify that they are who they say they are. So that's one, except that we've got two now. The third one is Social Security numbers. And this one is a little complicated. There is a general exemption in 119, I think it's 119.071 parens 5, for Social Security numbers. There are lots of specific exemptions for Social Security numbers. This is a general exemption that applies to every public record. For example, if you're a city employee or a former city employee, your Social Security number in your employment file is exempt from public disclosure. But what about your Social Security number in the public utility office? That falls under the general exemption in 119.071 parens 5. And that says that Social Security numbers in all public records are exempt from public disclosure, except that any commercial entity engaged in a legitimate commercial activity can get Social Security numbers for the sole purpose of identity verification. And in that case, under 119.0715, anybody, commercial entity engaged in a legitimate commercial activity, if they want the Social Security number, say, of the utility customers, they have to put their request in writing, they have to verify they are who they say they are, and they have to state the purpose of their request. And the only valid purpose is identity verification. Newspapers and reporters, broadcast media, are included within that legitimate commercial activity. So if a newspaper reporter goes to the utility office and wants the utility records, including Social Security numbers, they can get them, but only for the purpose of identity verification. So those are the three exceptions. I'm not aware of any others. So as a rule, you can't make them say who they are, you can't make them provide identity, and you can't make them put their request in writing. And a lot of people get really upset, government employees, when they realize that their personnel records are subject to public disclosure. There is information in those records that will be exempt. For example, the Social Security number, medical information. There's a whole list of information. Home addresses, as a rule, are not exempt from public disclosure. There are some government employees, law enforcement officers being one, judges, public defenders, state attorneys, code enforcement officers, the list is getting longer, whose home addresses will be exempt from disclosure. And the reasoning behind that is that a law enforcement officer is dealing with a fairly ugly segment of society on a regular basis, and we want to make sure that the officer and the officer's family have some extra level of protection. There's a case recently in Tallahassee where a woman had some kind of interaction with a Tallahassee Police Department, TPD officer. And the woman went to ratemycop.com and entered all sorts of information about this officer, her name, her date of birth. I don't know if she had her social security number. Her name, her date of birth, her home address, the names of all of her children, their dates of birth, where those kids went to school. All of this information is exempt in the public record. So an officer, where the kids go to school, where the wife works, or where the husband works, exempt from disclosure. This woman went and put it all up on the web, on this website that lets you be cranky about law enforcement. And the local prosecutor brought charges against her because there's a law prohibiting endangering a police officer's life, and the prosecutor thought this was endangering her life by putting all this information out on the web. So she went to court, and the judge threw out the case because she had gotten all of that information off the internet. She didn't make one public records request. So that was all information that was publicly available on the internet. And that's when people get upset about their home addresses. You have to think about what information is already out there. I had the Guardians ad litem wanted a home address exemption. I was very happy to give it to them because I think they do God's work, and we need people to protect those who can't protect themselves. And they came to my office, there were 5 of them, to talk to me about the public records exemption they were asking the legislature to pass. And as they walked into my office, I handed each one of them a copy of the page from their telephone book where their home address and telephone numbers were listed. And I went on to Google. I got the home address, where they worked, a map to their home, and where their spouses worked, in the space of about 10 minutes. If I want to hurt them, am I more likely to make a public records request? Or am I going to just sit there in my jammies and Google them? There are ways you can protect personal information about yourself on the web. You need to take those steps if you're concerned about it. You can't protect yourself 100% of the time. I can buy your social security number for $39.95. But you have to take those steps yourself and do what you can. Public records are not the source of evil. And access to that information is not the source of evil. In fact, the legislature has passed a law that says if anybody uses public record information in order to commit a crime, the punishment for that crime will bump up to the next level. So if it's a first-degree misdemeanor, it becomes a third-degree felony. We're focusing on the misuse of information. But generally speaking, if you've got a problem with identity theft or stalking, it's somebody you know, or somebody who has authorized access to the information they're using to commit the crime. But you have to think about it. You know, when I look at my niece's Facebook page, I'm like, does she ever want to get a real job? She was furious with me when she found out that a potential employer could demand her to be friended on Facebook. When I told her about the school teacher in Florida who got fired because somebody tagged her having a drink at a bachelorette party and posted it on Facebook, the teacher lost her job. I mean, we're all freaked out about privacy, and yet we're telling everybody what we're doing every 2 seconds and posting pictures. I told her she's lucky her grandfather doesn't know what Facebook is. It's scary. So think about it again, about what information you're posting. Some of it is beyond your control, like mugshots.com. You know what mugshots.com is? It's a Florida-based company. I got a call from a niece on the other side whose husband had gotten into some really stupid trouble. Cost him a lot of money to get his record expunged. He happens to be a highly classified scientist for the federal government, and his mugshot is on the internet. Mugshots.com. Don't go look up people you know, because that'll just make it come up more often. And she wanted to know what she could do to get rid of it. Nothing. It's a public record. Mugshots.com goes in and gets the mugshots of people arrested. Even if their charges are dropped, even if they're acquitted, doesn't matter. There's a mugshot. Now the problem is, and some state attorney generals are dealing with this because mugshots.com is in every state, and they have subsidiaries. And they'll say, pay us $400 and we'll take down your mugshot. But then it pops up over there, and it pops up over there, and you got to pay each one of those people. It's a racket, is what it is. And some states' attorney general are prosecuting and for extortion. We'll see how those go. But you want to be careful. I mean, you can't stop yourself from getting arrested accidentally. But be careful and think about what you post, and remember that it never goes away. You can scrub the internet once, you can't scrub it twice. Prompt response versus reasonable production. Rick, who wanted that database or that information within the hour. There is a difference between a prompt response to a public records request and reasonable production of the records. Section 119.071 says that requests to inspect or copy public records must be acknowledged promptly and in good faith. I have your request. I should have those records for you by the end of business on Friday. I got your request. I don't have those records. Why don't you call the city clerk? She either knows or has them. Prompt, good faith response. This was actually, this law was passed in response to a problem we were having with a former governor whose staff would say public records request would be made, and she would say, it was mostly one person, staff would say, well, I don't have them. Who does? I don't know. Not me. Or public records requests that were never acknowledged. I had a small businessman outside of Tallahassee contacted me after he had contacted the Attorney General. He had made a public records request 4 times in the space of 4 months to a school board, and they never acknowledged his request. Never responded at all, contrary to the law. So he, at my advice, went to the Attorney General. She contacted the school board saying, I've got a request for mediation. They didn't respond to her. So he came back to me. I made a public records request. No response. I made a second public records request. No response. I made a third public records request, and I said, okay, my patience now is at an end. Either respond as you're required to do, or I'm going to court this afternoon and filing a complaint. The next day, the records were delivered to my office via FedEx. The next day, I got a bill for $80-some for the FedEx package, which I refused to pay. They didn't tell me that. It's 5 miles from my house. I would have driven over there. But why did it take 4 requests from him, a request for mediation from the Attorney General, and 3 requests, and finally a threat to get very simple documents that are requested all of the time? It shouldn't be that difficult. So you prompt good faith response. I got your request. I'm working on it. It's a little complicated. I'm not sure how much it's going to cost yet. I'm not sure how long it's going to take. I'll get back to you as soon as possible with an estimate. I don't have those records. I have no clue what you're talking about. Try this person. Prompt good faith response. And then you have a reasonable period of time in which to produce the records requested. The court said that reasonable means the time it takes to locate the record, to review those records for exempt information, and to provide a copy. So it could be a matter of minutes. I come in, I want a one-page memo, photocopier is right there. Just make the copy. I come in, I make a public records request, they got records over in this division, that division, some are archived off-site. It might take you 3 weeks just to figure out where they all are. And it might take me 8 hours or 10 hours to review the records. It's reasonable under the circumstances. You do not have to drop everything in order to comply with a public records request. But neither can you put it at the very end of your list after you've cleaned out your desk and scrubbed out the trash can and cleaned the refrigerator. Okay, then I'll do it. You work it in. You have a statutory and constitutional duty to provide access to public records. My advice, and I do this simply because if I don't do it, I forget to do it. If I've got the time, I'll just do it now. Particularly if somebody wants something emailed, I'll just email it to you. Here it is. Rather than saying, well, I'll do this on Friday. By the time Friday comes around, I could be so busy or so bored, I forget to do it. But reasonable production. No artificial time limits. The city tells Mr. Smith it's going to take 4 hours of staff time to compile the requested records, and it gives him a cost estimate of $250. Mr. Smith is asked to pay the estimated fees before they start making copies. Does Mr. Smith have to pay the estimated cost in advance of getting his copies? Yes. Yes. The custodian of public records must furnish a copy or a certified copy of the requested record upon payment of the fee prescribed by law. This is very effective if you have someone who is constantly making public records requests and then not coming to pick them up. Or it's a big job and it's going to take a lot of time. You can ask them to pay up front. If you ask them to pay up front, you have to give them a good faith estimate of how many pages and what costs are being levied. And you have to give them that estimate in writing. I always recommend a policy, a written policy which the city is working on, which says if your request is going to cost less than $5, we're not going to charge you at all, because it costs us more than $5 to record the payment of $5. If your request is going to cost more than $100, you pick the, I'm just picking numbers out of that. If your request costs more than $100, we're going to ask that you pay the estimated fee in advance of production. That way, the real cheap ones, you can just give it to them. The ones that are kind of in the middle, doesn't really big deal. But if it's going to take me hours of staff time, that way, if you have it in writing, you then have to actually, apply it uniformly. But you have something to point to when people start fussing, because they will fuss if you say you have to pay in advance. They will fuss. But you don't want everybody to have to pay in advance. That's kind of dumb. When Governor Scott, I mentioned that I was making these public records requests, I did this as actually as a gesture, being nice, because when he took office, he came from the private sector. Most of the people who worked for him came from the private sector. They had no clue about the public records law. And they got overwhelmed with public records requests. And he dismissed the woman who had been running the Office of Open Government and hired somebody with little open government experience. So they were kind of caught. And the press corps, which can be very aggressive, was making a lot of public records requests for the email correspondence of his top staffers. So I went and talked to the woman who ran the Office of Open Government, and I said, what about this? I'll make the public records request every Monday for the previous week's emails. And you give me those, and I'll take them, and I'll put them in a drop box and let anybody who wants them have access. Therefore, you're dealing with one public records request rather than 20 or 30 public records requests. Great idea. Right after I agreed to do that, the governor adopted something called the fee recovery policy. And the fee recovery policy said, if your request costs less than $5, we won't charge you. If your request costs more than $5, you have to pay in advance, more than $5. And we do not accept credit cards. So I have to write a check for $5.52, which takes me, all right, I go to the bank, I do everything electronically, but they don't accept things electronically, so I have to go to the bank, I have to enter this payment. It takes 5 days for the check to get to the governor's office. Then it takes them another 5 days to record the payment. Then it takes them another 5 to 10 to 15 to 30 to 90 to 120 days to provide me with the records I've requested. It was a nightmare. I had to create a spreadsheet, and I'm not good with spreadsheets, because every request I made got a number. Every number, I'd then get an estimate. Once I got the estimate, I had to cut the check. Once the check was received, I got an email saying, we received your check. I waited over 6 months to get 30 emails. Then they started charging me the hourly rate of the person whose emails I had requested, if it took more than 15 minutes. Well, some of those people were making $200,000 a year. And I'm paying their hourly rate for them to review their emails for public records emails. Why are we wasting this person's very valuable time? It was a total nightmare. I'd get some one week, I'd get some the next week. It was the biggest mess. And it didn't have to be that way. And he did amend his policy in light of that. So you can charge, but if you're going to ask people to pay in advance, be reasonable about it, set reasonable amounts, and figure out an easy way for people to pay. I mean, it was very difficult to pay. I actually one time thought, well, I'm just going to give him, first I thought I'm going to, give him 6 $100 bills for something that was, like $601. So he's going to have to come up with $99 and change. He did. Then I paid him in nickels, pennies, and dimes. I tried everything to get them to pay attention, and they finally did change their policy, but it wasn't thinking about the practical reality of making people pay. You're allowed to make people pay, just make it easy for them to pay. And this brings up the other one issue that I was asked to address too. I made a public records request every Monday for the previous week's email. You do not have to provide access to records that do not exist. And there is no such thing under Florida law for standing public records requests. In other words, I can't make a request today for all email correspondence for all city commissioners from this point forward. That's not a public records request that's recognized under Florida law because those records don't exist. Or when you come out with the city budget next month, I want the budget, the draft budget. No, the record doesn't exist. I can say I want all correspondence of the city commissioners from this point back 2 months, but not from this point forward for 2 months. You can only request records that are in existence. So what can you charge? The law says 15 cents a page for paper copies up to 8.5 by 14 inches. So legal size paper. If it's a two-sided copy, it's 20 cents. And it doesn't matter whether it's black and white or color. 8.5 by 14, 15 cents a page. If it's 11 by 17, it's the actual cost of duplication. If it's, I want it on a CD, actual cost of duplication. And actual cost of duplication is defined in law as the actual cost of the material and supplies used to duplicate the record. Labor and overhead costs are specifically excluded, and those costs cannot be passed on to the requester under that first fee provision. So it's 15 cents a page for paper copies or the actual cost of duplication. The actual cost of the materials used. I was helping a citizen who was having problems because his city commission was charging $25 for every CD. And I said, and they insisted that it cost them $25 per CD. And so I suggested that the citizen make a public records request for the invoice showing that they were paying $25 per CD. And the clerk got a little annoyed with me, and I said, I will donate to the city a membership to Sam's Club. CDs don't cost $25. They cost 30 cents, 35 cents, 50 cents, 60 cents, depending on how many you buy and where you buy them. The actual cost. There are other statutorily authorized fees, fees prescribed by statute. City governments don't have any statutorily prescribed fees that I'm aware of. If it's a certified copy, it's $1 per copy for a certified copy of a public record. This one doesn't apply to you because it's county constitutional officers. So 15 cents a page or the actual cost of duplication. If I come in and I hand you a ream of paper and said, here, make my copies on this, you can't charge me for the cost of duplication. If I come in with my personal laptop and my handheld scanner, or what's more frequently happening, my smartphone, and I want to photograph the records myself, you can't charge me for the cost of duplication. So if I provide the copying material or I make my own copies, you can't charge me that 15 cents a page or the actual cost of duplication. We had it was a number of years ago, a newspaper in South Florida was being asked to pay a ridiculous amount of money for some public records, so they rented a Xerox machine. And it was a long time ago. And wheeled it into City Hall and plugged it in and made their own copies. And the city tried to charge them for the electricity and the space they used. And the court kicked it out, saying those fees are not authorized under Chapter 119. You can't charge them. Now, we'll talk about supervision in a minute when somebody's photographing or inspecting public records. But the point is, if they provide you with their own copying supplies or they copy themselves, you can't charge them. You don't have to take the paper or the thumb drive, because thumb drives can cause viruses. What people do, there was a big issue. At first I thought it was one of those urban myths, but it wasn't. Somebody was infecting thumb drives with viruses and scattering around in like the Walmart parking lot, the floor of McDonald's, you know, and people were picking up and go, wow, a thumb drive. So you don't have to take them. You don't have to use them. But if somebody offers you one, I wouldn't charge them for the cost of the duplication, just to not argue about it. I just wouldn't. And one clerk called me up and she said, this woman keeps bringing in paper and it's really crappy and it jams my machine. So don't use it. But you're also not paying 15 cents for each photocopy you make. So you don't have to take the materials, you don't have to use them, but you shouldn't be charging them if people offer them. So according to the breakdown of the fees provided by Mr. Smith, the city has also included a charge of $50 an hour for 4 hours of staff time needed to find the records Mr. Smith has requested, to review those records for exempt information, and to make copies. Can the city charge Mr. Smith for staff time? Yes, under certain circumstances. The extensive use provision. So we've got the 15 cents a page or actual cost of duplication. Now we've got extensive use. Two different things. The law allows an agency to charge, in addition to the cost of copying, a reasonable fee for the extensive use of agency resources, whether that's personnel or information technology or both. And you can charge that in addition to the actual cost of duplication. The fee must be reasonable and it must be based on actual costs incurred. Most agencies, 99% of the agencies I deal with, will charge for personnel time, but they do not charge for information technology because they can't figure out what it actually costs them. Automatic application of the extensive use fee is prohibited. That means that every agency has to determine what is an extensive use of its resources. There's one court case on this. The Department of Corrections defined extensive use as 15 minutes or more. And a lot of agencies kind of glommed onto that definition, but I think that was a mistake. That everybody should define for themselves and have some justification for the definition. The average seems to be, or the most common definition I should say, seems to be 30 minutes. But I've heard as short as actually the shortest I ever heard was 1 Mississippi. And as long as 4 hours. The Attorney General, I think, is 2 hours. Because they looked at how long their average public records request took them to fill, determined that anything over that average was an extensive use of their resources. So an automatic application is prohibited. You can charge if the request requires an extensive use of resources. So you should have a definition and a justification. Let me go back. If you're talking about staff time, you can charge no more than the hourly rate, including benefits, of the lowest paid person capable of performing the task, even if that person didn't actually do the job. So if we're talking about photocopying, the part-time clerk who makes $10 an hour is on vacation and her supervisor had to make the photocopies, you can't charge any more than that part-time person's hourly salary, including benefits. So the hourly rate of the lowest paid person capable of performing the task. And some requests, you know, the routine request, I go into the personnel office and, you know, everybody knows it's routine, we know what is exempt and what's not exempt. We have the office clerk do it. Some requests are going to take say the city clerk, might take the city attorney, might take the city engineer to determine. And if it's the city engineer is the lowest paid person capable of figuring out what is exempt in that record, then that's what it's going to cost us. So the hourly rate of the lowest paid person capable of performing the tasks. I do argue with some policies I've seen that every public record requested must be reviewed by the agency attorney. Why? That's adding costs to my request. It's unnecessary, and it's taking up very valuable time that could be better spent elsewhere. Not every request has to be reviewed by the city attorney. Some will be. I was talking to some city, and I said, you know, there's this data out there, and I said, only the engineer would know what that is, and the engineer was in the audience and said, no, I don't. Well, somebody has to. It's exempt. So you can charge for review and redaction if review and redaction requires an extensive use, but you can only charge the hourly rate of the lowest paid person capable of performing the task. I've already talked about this. If they make their own copies or provide the material and supplies necessary to duplicate the record, the custodian can't charge copy fees. But you may be able to charge a supervisory fee if supervision requires an extensive use of resources. Yeah.
Did you say it would be okay to ask questions during the process?
Yes, I did.
May I ask one?
Yes, go ahead.
So this question has to do with the charging of fees. So if the city is in litigation with someone, and the attorney who is litigating against us is asking for public records.
To avoid discovery?
That could possibly be. I do not know the intention, so I don't know. And so we believe that it is necessary to have an attorney review those records. Is the city then allowed to charge for attorneys' level of actual cost?
I'd ask Pat Gleason that question. Pat Gleason runs the Open Government Mediation Program in the Attorney General's office and actually writes the Government in the Sunshine Manual. I would say no. Because what you're doing is basically adding a level of protection that may or may not be necessary. And let me put it a different way. If the records are not records that are routinely requested, and you get the request and you're looking at this and you say, I don't have a clue whether these contain exempt information or not, and you turn it over to the city attorney, that would be legitimate. But if they are records like personnel records, where it's clear what's exempt and what's not exempt, and you just want to make sure that you got everything before you give it over to opposing counsel, I would say you're covering yourself, which is a good thing, but I don't think you can then legitimately charge the requester that extra fee. But I would ask Pat Gleason. That would be my argument. I mean, you're doing something that you should be doing to protect the best interests of the city, but not necessarily something that's required under the public records law. Does that explanation make sense? Okay. So in that case, before I charge, particularly if you're already in litigation, I would ask Pat Gleason to see what she had to say. Either that or just don't charge them. If you have a legitimate question about whether this information would be exempt and whether a specific exemption would apply, then certainly you could charge those on. But if you know what you're doing and you just want the attorney to give it a second glance to make sure you got it all, I don't think you could pass those costs on. Any other questions? The point of a lot of this, and this is something that's lost frequently, fees have to be reasonable. When I worked on the CRIST Commission on Open Government Forum, we went all over the state taking public testimony. And a woman said, you've got to do something about the fees for public records. I made a public records request in my county or my city, and it was more than my mortgage. And I had the choice of either getting my records or paying my mortgage. It shouldn't be that way. A reporter I was working with last year, $67,000 for public records. He was trying to find out I guess, I don't know, like I said, I'm a one-trick pony, but the Department of Juvenile Justice pays per bed in juvenile facilities. Whether that bed is occupied or not, they pay the same rate. And so this reporter was trying to find out how much we were paying for empty beds. $67,000. The ACLU has just filed a lawsuit against the Department of Corrections on a similar issue, bed occupancy. Department of Corrections says we have that information, but it's in our computer, and they're entering this information every week, mind you. Every week we're putting that information in our computer, but our computer system is so antiquated we can't retrieve it. What? That's like putting your money in a box and you don't have the key. Fees have to be reasonable. And I don't know, I don't want access to public records to cost the city money. I want you to be able to recoup your costs. It should be a zero-sum game. But when a reporter in South Florida is told it's going to cost her $60,000 for a school board to retrieve information about their volunteer in the classroom program, she calls me. I said, $60,000, how many volunteers are there? Well, then the cost dropped to $30,000. Then she drove up to Tallahassee and interviewed me on camera, and the cost dropped again. And then it turns out they didn't have the records. They were supposed to be doing background checks on all of these volunteers in the classroom, and they hadn't done them. Now, that doesn't happen very often. It's usually our system's broken, we just don't know what we can charge. It's rare, in my experience, in Florida, at the state or local level, it's rare that they're trying to obfuscate. Some cases it is, but not very often. It's usually the system's antiquated. I had I can't remember if it was a reporter or a citizen sent me an email response. She had made a public records request from a local government, and the response was, we've got those information, but we've laid off all the people in our IT department and nobody knows how to use it. Yeah. Remember, this is a constitutional right. We have a constitutional right. And you have a statutory and constitutional duty to provide records. So we just have to figure out how to do it in the most cost-effective, least painful way for the city, the school board, the police department, and the least painful way for those people, and most cost-effective way for those people wanting access. And we can do that. There's technology today that can do anything. Okay. Mr. Smith has now changed his mind for the billionth time and says he simply wants to inspect the records requested. He doesn't want copies. The city determines that the records have been archived and stored off-site. A staffer meets Mr. Smith at the facility and supervises him for the 4 hours it takes to inspect the records. The agency then asks Mr. Smith to pay $200 for supervisory time, $50 an hour for 4 hours of staff time. Is that okay? It's a trick question. Yes. Sorta. It's okay for them to charge for the supervisory time. But why are we paying somebody $50 an hour to sit in a dank warehouse? Don't we have somebody making $10 an hour who could do that? Lowest paid person capable of performing the task. You do have a statutory duty to protect public records. You must make sure that records are not altered or destroyed. Who was it? Strobe Talbot, who walked into the Library of Congress, rolled up a bunch of documents, stuck them in his pants, and walked out? You have to make sure that records are not stolen, altered, or destroyed. So if supervisory time requires an extensive use of agency resources, you can charge. You can't charge for the cost of copying. You're not making copies for them. Even if you have to make a photocopy to redact on the photocopy, you cannot charge him for the cost of that copy. He doesn't want it, he's just looking at it. You can charge him only for the cost of copies he takes with him. So you can charge for supervisory time if supervision requires an extensive use. Now, we have to go to the warehouse to sit with Mr. Smith. What if it's just, like a file or two and you've got it on your desk and you just make a spot for Mr. Smith in your office? There's no justification for charging him for the supervisory time. We're not taking you away from your job. But if you have to go sit in another room or go down to the warehouse, then there's justification for that. And there's one other point I would like to make. If we're supervising, the supervisor cannot be the subject of the record. I got a freaked out phone call. A woman had made a public records request for the personnel file of a law enforcement officer. She had filed a complaint against this law enforcement officer, and she wanted to see if there had been other complaints and to see his, evaluations and that sort of stuff. So she made a public records request to inspect his personnel file. The city made an appointment with her. She went in at the appointed time. They showed her into a small room with a little table and a door. She sits down at the table, and in walks the police officer with his personnel file, slaps it on the table and says, "What do you want to know?" Can't do that. It was intimidating at best. You're allowed to supervise. You're allowed to tell an employee that a public records request has been made for that employee's personnel file. You're allowed to. You can't delay the request while you inform, but the supervisor cannot be the person who is the subject of the record. It has to be some neutral party. And also, all the good stuff, personnel-wise, has to be maintained with all of the bad stuff. So if we had good evaluations and bad evaluations, and all of the evaluations are in the personnel file, all of the evaluations have to be in the personnel file. There was an attorney general's opinion, there was an employee. The policy of this agency was that all of the bad stuff went in the bad stuff file and all of the good stuff went in the personnel file. And so if you made a public records request for the personnel file, you only saw the good stuff. Oh, we didn't know you wanted the bad stuff. That's over here in another file. You have to make a public records request for the bad stuff file. Now you got to keep it all together. Mr. Smith doesn't want copies. He doesn't want to inspect. He wants the records in an electronic format. He learns that the record is maintained in Excel, and he asks for the record in their native electronic format. Does the agency have to give Mr. Smith the requested record in Excel? If he requests it in Excel and you have it in Excel? Yes. An agency must provide a copy of a public record in the format requested if the record is maintained in that form. If you have it in Excel and I want it in Excel, I get it in Excel. If the record is not in the format requested, the agency has the option of converting it and charging me a fee if there's a cost of conversion. Usually now with today's technology, my husband, who we won't even talk about his flip phone and his inability to answer it, cannot open a DOCX document. He can't. And he's constantly battling with people because they're always sending him documents and he can't open them. And I've showed him like 35 times how he can just right-click it and pick the format he wants it in, but he doesn't understand that because he can't answer a flip phone. The cost, the time it takes to convert from DOCX to DOC or to PDF is minimal. It takes a second or two. So generally there wouldn't be much of a charge for converting it. The point, though, is that you have to provide access to public records in some meaningful form. So if you're dealing with my husband and he can't open a DOCX, just send him a PDF. He can open a PDF. He doesn't realize that he can't change a PDF, but he can open a PDF. You have to give it to them in some meaningful form. If you have it in Excel and it's requested in Excel, you have to give it to them in Excel. And I always get this, well, you know, I don't want to send him our budget in Excel. He could change it. And what's the point? Of course he can change it. That doesn't alter the public record. You still have the public record. He could manipulate it to his heart's content. He could save you $2 million. He could probably save you more than that because he is also funny with numbers. The point is, if I ask for it in its native electronic format, you have to give it to me in whatever format. And this is really important with not just Word documents, but also email. I want that email in its original format. Because if you, and I think this is the PDF issue, if you make a PDF of an email, you have basically given me a photocopy of that email. Even though you can transmit it to me electronically, you have given me a photocopy. It's not the same as getting the original. In the original, I can find out who was CC'd, who was BCC'd, I can see the attachments. All of that information, all of that metadata that the NSA keeps talking about, oh, don't worry, it's just metadata, is very important. And it's all part of the public record. If you send me, I want a document in Word, I can go in and look at that document and see how it has been altered. That's important. If you send me a PDF, it is just like an electronic photocopy. You cannot make somebody take a PDF if they've asked for the original native electronic format. You have to give it to them in whatever form or format in which you maintained it. Anybody have questions about this? It comes up a lot, actually. With people wanting it in Excel, they want that, and I use that phrase, native electronic format. I might not have the software or the ability, but I can find somebody who has it and can convert it into some format in which I can understand it. Uh-huh. Yeah, so everybody can hear you.
My question is this. When I make an open record request and ask for emails, I'm given them on a disk that I cannot open. I do not have the means of opening. Now, do I have the right to ask for those emails in another format that I can't open? And what would that format be?
Paper.
Paper? Okay.
I mean, paper, PDF. If you want them sent electronically, I mean, you can search a PDF. You can't. I mean, it's interesting when this law was in effect in the wake of the 2000 election, and you know what the 2000 election did to Florida. And every reporter in the universe wanted the email correspondence between the governor, Jeb, and the members of the Electoral Commission. That was Catherine Harris, Secretary of State, Bob Butterworth, Attorney General, and I'm forgetting his name. He was the Secretary of Agriculture. Bronson. Because Jeb had to recuse himself. So public records requests were made. And Catherine Harris called me up and she said, I got these public records requests and they want it in the electronic format. And I said, yeah, they have a right of access to that. And she said, okay. So she put it on a CD. Bronson was a little bit behind the times. He put his on a floppy disk. Floppy disks were still around then. I think I have now the only floppy drive. I have an external floppy drive. Butterworth just emailed all of his email to whoever requested. I thought that was brilliant. He just sent him an email and attached all those emails. The governor gave us, I can't remember exactly, it was like 76,000 pieces of paper in no particular order. Which is more valuable and useful? And by valuable, I mean useful. The CD, even the floppy drive, or 76,000 pieces of paper, which we then had to sort through, put in date order, which is a reply to which. So I was only involved in that at that point in helping the requesters. I made a public records request and requested 3 days of email correspondence from the governor in its native electronic format. I got a call from his general counsel saying, why do you want that? I said, I don't think that's any of your business, why I want that, and you shouldn't be asking me that question. I know him very well. And then he said something else, and I said, well, you know, why don't I come up to your office? And I went up to his office and I said, I handed him the complaint. We were ready to file in court the following day, and I said, you know, the law says you have to give it to us in its native electronic format. You're forcing us to take paper. You're in violation of the law. Just give it to us in the format and we won't file this lawsuit. And they did. And they started giving it to us in the electronic format from that point forward. But that's sometimes what it takes. And you have to give public records to people in some meaningful form. Most people will take it the PST format, and there are programs you can download for free that will convert a PST to whatever you've got. Most people want them in some electronic format. Others, like my dad, he couldn't open a CD. He'll want it in paper. So you have to give it to him in some meaningful form, and then you get to charge them for the cost of copying, which is why most people want it in native electronic format, because it's more useful and it's cheaper. And it's easier for you. You know, some agencies, and this is one way that you can avoid a lot of the hassles of complying with the public records law, more and more frequently now, local governments and state agencies are proactively posting commonly requested public records on their internet, on their websites. So you get constant requests for the budget and the budget work papers, just put it on the internet. You put this presentation on the internet, it's a great idea. 3 people have asked me for it. Go to the website. I mean, I'll email it to you, but it's right there on the city's website. And that is happening more and more frequently. Salary information. You get constant requests. You don't have to necessarily put the names of the employees, but you put their position and their salary. It's happening more and more frequently, and it's a way to cut down on people coming into your office making requests for routinely requested public records. Sensitive information, I wouldn't put personnel records up. But routine information that's commonly requested, minutes from your meetings, those sorts of things, stick them up on the website. And people will start going to your website. And that really does help everybody. Okay, we have a presumption of openness. All records are presumed open and subject to disclosure unless there is a specific statutory exemption. Only the legislature can create an exemption to the constitutional right of access. Commissioner Smith gets a letter from a constituent that says, keep this between us. This is confidential. No, it's not. Not unless there is a specific statutory exemption. It doesn't matter what the sender of the document wants. If it's not exempt, it must be disclosed pursuant to a public records request. Envelopes that letters arrive in are public record. Got a call, woman, worked for the city. Somebody sent us an anonymous letter, and I got a public records request for the letter and the envelope in which it arrived, and in the return address, it has the name and address of the person who sent the anonymous letter. Public record subject to disclosure. Yes?
Okay, if a public records request is made, say for a councilman's emails, and the city says that the councilman has to review that for emails that are subject to exemption before they hand over the emails to you, which happens. And then once you receive the email, what is the city's responsibility in terms of keeping records of anything that was exempted and letting you know that something was exempted and why it was exempted?
They have to, we're going to get to that in 1 second.
Okay, cool.
We're going to get, and I would, question why the commissioner, I could see the commissioner, being asked to, particularly if he's commingled public records with personal records, in other words, public record email with personal email, if that's commingled, I can see asking the commissioner to separate out the public from the private. But I would question why the commissioner would be asked to redact exempt information, because the chances are that the custodian coordinator or your city clerk would have a better idea of what's exempt than the commissioner would. And I would also, again, don't put exempt information in a public record email. I had a wonderful employee who came to me because she'd gotten fired. She worked for the state courts administrator, and she had this very a personal relationship, very jokey relationship with a couple of other people on staff, and she made some racy, nasty joke about the Chief Justice that she mistakenly sent to the entire email list in the state court system. It was actually a true story that I won't repeat. But it had something to do with mirrors on the ceiling and something else. So she got fired, and I hired her. She was great. You just have to, you don't know what you're sending always, and you don't know what those people who you send it to, you don't know what they're going to do with it. So just be careful. Only the legislature can create exemptions. Courts cannot judicially create any exceptions or exclusions to the public records law. There is no balancing of interests. There is no right to privacy in a public record. The legislature does a very good job of drawing sometimes what is a very fine line between information that is sensitive and should not be released, and other information. As I said, people get all excited about the home address being subject to public disclosure. You don't have a privacy interest in your home address. You have a privacy interest only in that information which you can expect to keep private. Your home address is on the front of your house. Mr. Smith is getting testy. The city denies his request, and this gets to your question. He demands to know why his request has been denied. Does the city have to tell him it? Yes. It is your responsibility to tell me why I can't have the record. It's your responsibility to provide me with a statutory citation authorizing the denial of my request. And if I ask you to put that denial in writing, you must do so. I don't have to put my request in writing, but if I asked you to put the denial in writing, you have to do that, and you have to include the exact statutory citation. That's why your membership in the First Amendment Foundation is going to be so valuable, because you'll have access to that exemptions database. So the public records law is to be construed in favor of open government, and exemptions from disclosure are to be narrowly construed. Agencies claiming exemptions bear the burden of proving the right to the exemption. If an agency denies a request for public records in whole or in part, the agency must put the denial in writing and provide the exact statutory citation authorizing the denial. And they're to be narrowly construed and strictly applied. I had about 6 emails today from a reporter who made a public records request for an incident report. It was an ATM robbery, and the law enforcement agency redacted the victim's telephone number. Not her name, not her address, not her date of birth, but her telephone number. And when she asked for the citation, they cited something that just doesn't apply. And so we've been going back and forth, and they finally said, oh, I'm sorry, we made a mistake. Here's the phone number. Or here's the unredacted document. Mr. Smith is told that he can't have one of the records he's requested because it contains both exempt and non-exempt information. Can the city deny his request because the requested record contains information that is exempt from public disclosure? No. This is your specific question. If a record contains both exempt and non-exempt information, the keeper of the record must redact that which is exempt and provide access to the remainder. If you're redacting information on a paper record, make a photocopy of that record and redact on the copy. Do not redact the original. I don't make this stuff up. Total freak out when the head of personnel went on vacation for 2 weeks and her new assistant got tired of redacting all those social security numbers, all those home addresses for the law enforcement officers. So she sat down one day and just took a magic marker and personnel director comes back and she's got 3,500 personnel records with no social security numbers. Destruction of a public record. Inadvertent, unintentional, but to redact on the original is a destruction of public record. So agencies cannot ordinarily charge for the cost to review records for exempt information, but you may be able to charge if review and redaction requires an extensive use of your resources. I know a lot of attorneys who really hate that, and they're trying to change it. Once we get better electronic record keeping systems and use better software, redaction should be less of a problem. But right now, it's a huge problem, and it costs a lot of money. This is important, excuse me. It's important to understand the difference here between information that is exempt from public disclosure and information that is confidential and exempt. And this is also why it's important to read the exact statutory language. As I said, the manual contains a summary of the exemptions, but I don't know that it always makes the distinction between exempt and confidential and exempt. Information that is exempt from public disclosure can be released at the discretion of the custodial agency. The best example is active criminal investigative information, the ATM robbery. There's a security camera. We get a grainy photograph of the robber. Law enforcement gets the Pensacola News-Journal to run that picture in an attempt to help identify the robber. If the Pensacola News-Journal made a public records request, active criminal investigative information is exempt from disclosure, and law enforcement would not have to release it. But because it's merely exempt, they can release it at their discretion. Information that is confidential and exempt cannot be released except as specified in the exemption. I was talking about Social Security numbers and personnel files. Those are confidential and exempt, and there is no authority to share those numbers with anybody. So even if, FDLE comes and said, we want to verify that Michael Smith was an employee of the city of Pensacola, we need his Social Security number for his employment file. Sorry, FDLE, you can't have it. Most information that is confidential and exempt, the exemption will contain some ability to share with other governmental entities in the furtherance of their governmental duties or something. This one doesn't say anything to that effect. So you want to read it, because if you give information that is confidential and exempt to someone not authorized to receive it, you could be found to have violated the law. And a lot of the exemptions that the legislature has been creating lately, they're making it a penalty, a criminal penalty, to release the information to anyone not authorized to receive it. It's a third-degree felony to knowingly give information identifying the victims in a car crash to someone not authorized to receive it. A third-degree felony. You won't be able to vote. So read the exemption, make sure you understand it. If you have questions, you can call me, you can call Pat Gleason, you can talk to your attorney, city attorney, not your personal attorney, to make sure you're allowed to release it. Access to records subject to public disclosure under Florida law can be denied only when there is an absolute conflict between state and federal law. If federal law requires particular records to be closed and the state is clearly subject to those provisions, the state must keep the records confidential. What the legislature has been doing in the last 10 or 15 years, FERPA, for example, the Federal Education Records Privacy Act, requires that student academic records be kept confidential. That's federal law. The state then comes in and creates an exemption that mirrors the federal law. The only one that they haven't done that with, that's Driver's Privacy Protection Act. The feds passed the Federal Driver's Privacy Protection Act, which requires that personal identifying information in a driver history record be exempt from disclosure. State mirrored the federal DPPA. The only one they haven't done that with, to my knowledge, is HIPAA, which is the Health Information Privacy Act. That is the stupidest law on the face of this earth. And they haven't done anything with HIPAA. HIPAA is the most misinterpreted and misapplied exemption. I was telling people at lunch, I have a city animal control district that is trying to deny access to a dog's medical records under HIPAA. That's the only one, but they're always in. And it's, a lot of people think that the Patriot Act protects information. There is no exemption in the Federal Patriot Act. As I said earlier, there are some exemptions under Florida law for certain information like blueprints and schematic drawings, security plans. Those are exempt under state law. There is no exemption under federal law for that information. This is another problem we get frequent questions about. You work in the building department and an engineer has submitted building plans and they're copyrighted by the engineer or by the architect. Somebody comes in and makes a public records request. Do they have a right of access? Yes. Federal copyright law, oddly enough, does not prohibit the copying of copyrighted material. When you go into the public library and you go into the copy center, they got all those copy machines and they got all those warnings saying, be careful, be careful, be careful. You may be copying information that is protected by federal copyright law. The federal copyright law does not prohibit the copying of copyrighted material. It prohibits you from appropriating the creator's financial investment. In other words, if you get your hands on copyrighted architectural plans, you can't copy those plans and then sell them to people to build houses. That would be a violation of federal copyright law. I suggest that you get a big red stamp that says this document is protected by federal copyright law, 16 U.S. code, whatever it is, and so everybody's on notice that it's copyrighted. But I have a right of access to documents, public record documents that are copyrighted. So an intentional violation of the public records law is a first degree misdemeanor punishable by a fine of up to $1,000 and a jail term not exceeding 1 year. Bigger penalties, stiffer jail term than for the Sunshine Law. Unintentional violations are non-criminal infractions punishable by a fine not exceeding $500. Anyone who has intentionally violated the law can be suspended or removed from office, and you will have to pay attorney's fees and court costs. The NCAA, purely private corporation we talked about, paid $360,000 in attorney's fees and court costs for a violation of the public records law. I hate to tell you this, but the only person who's ever gone to jail for an intentional violation of the public records law was from Escambia County. You're in the record books. So if you need help, there's my email address and there's my office phone number. I travel a lot. My cell phone doesn't always work, but I always have email. So either email me or call my office and my office will tell you how to get in touch with me. And then this is Pat Gleason's email address and her direct telephone number. She runs the Open Government Mediation Program. She writes the Government in the Sunshine Manual. She's a wonderful help and a wonderful resource, and we pray that she's not retiring next year. But she is very helpful, and you can call her directly. You can always call me. As I said, it stays with me. I don't pass it along. So call me if you have questions or need help. We are going to have a lot of information available on our new website very soon. We're even going to have an app that will be free for download about how to access public records. We used to have this little pocket card that people, what to say if you're denied access to a court proceeding, what to do if you're denied access to a public record. We're now putting that on an app. But on our members only page, we also have a very brief explanation, much smaller, it's like 10 pages, of the Sunshine Law and Public Records Law, which is a great thing to give to your newly elected officials and commissioners and that sort of thing. So if you have any questions, there's lots of places to go for help. I want to thank again the mayor, the staff, the theater people have been great, and if you're really not too tired, you can come back tonight at 5:30. Thank you all very much.